All right, the next item on our agenda is an update of the pending litigation with Verizon, LIPA, and the East End Eruv Association. And we've invited our attorney in that matter, Brian Sokoloff, to provide an update. And Brian's here, if you want to step up.
Thank you, Mayor. I thought that it was a good idea to have me update the community on this litigation because the mayor and the trustees dutifully followed my advice, which is not to comment on pending litigation. And I know that as a result of that, they've been accused by some of hiding behind their lawyer. And so I don't want anyone to get the wrong idea that there's anything to hide here. What I'd like to do is update the community on the status of the litigation. What I will not discuss is my advice to the board. What I will not discuss is what our options are, what our strategy is. In my view, it's grossly irresponsible for any attorney, actually representing any client, but particularly representing a government client, to discuss strategy and options publicly. It's not something that's done. If the federal government, the state government, the city, the county, no party in litigation stands up publicly and says, this is what we could do, we're strong here, we're weak here, this is what we should be prepared to do or not prepared to do. Nobody negotiates publicly, nobody discusses strategy publicly. And if anybody has the idea that somehow the trustees were hiding on this litigation or that something is being done underhandedly, it's just not accurate. So what I thought I'd like to do is just give a background on this litigation and tell you where we are. So this matter started a couple of years ago when the East End Eruv Association and LIPA and Verizon brought lawsuits against the three municipalities, that's West Hampton Beach, Quogue, and the town of Southampton, and accused those municipalities of standing in the way of their establishing an Eruv, which they say would require the affixture of certain items called leckies to certain utility poles throughout these municipalities. When the case first came in, it was clear that, to me anyway, that West Hampton Beach had done nothing to impede or prevent the establishment of an Eruv. And therefore, it seemed to me, this case was premature. The village is being sued for preventing this group and the utilities from establishing an Eruv, but in fact, the village had done nothing. Now, what they alleged was that in 2009, the mayor and the trustees of this village sent a letter to Verizon that said the following, quote, "It's the board's understanding that Verizon has again been discussing with the Hampton Synagogue an agreement that would result in attachments to utility poles owned by Verizon and/or the Long Island Power Authority located within the village limits in order to create an Eruv under Jewish law. The board further understands Verizon's position to be that it will not execute the proposed agreement and will not take or permit any action with respect to utility pole attachments unless and until the village approves the attachments. They argued that that letter said that the village requires an application. In my view, it doesn't quite say that. When the case came in initially, the plaintiffs immediately sought a preliminary injunction, which is an order from the court at the beginning of litigation that would prevent the defendants from doing what they wanted the preliminary injunction to do, which is they wanted the court to order the municipalities not to stand in the way of an Eruv. The judge, getting this motion for a preliminary injunction, immediately convened a hearing. It was like a trial. It was, I think, 3 days in federal court in Central Islip. The plaintiffs called witnesses, we called witnesses, and at the end of the day, the hearing record was put together. And in that hearing, the village asserted that there is no sign law in the village that prevents leckies on utility poles. The way that the village ordinance is written, the building inspector, who's charged with interpreting the code, didn't construe the sign ordinance to bar it. Nonetheless, throughout the hearing, we argued we shouldn't even be in this lawsuit because we haven't done anything. What they want to do is go before a federal judge and get free legal advice from the federal judge, and you can't do that. At the end of the hearing, the judge denied the application for a preliminary injunction. Why? Because, he said, Southampton has a sign law that requires an application. They never applied to Southampton, and therefore I'm not granting a preliminary injunction because their proposed Eruv would include Southampton. So Southampton is really now out of the case because they never applied to Southampton. The judge said to them, if you want to go apply to Southampton, then you can come back and sue Southampton. Nonetheless, the case can continue against West Hampton Beach and Verizon and Quag. When we initially, as I said, made a motion to dismiss, we won the preliminary injunction motion, but the court denied our motion to dismiss the case. And so we had a case. We again moved to dismiss in 2011, winter 2011 to 2012, but the plaintiffs amended their complaint. What they did in amending their complaint is they dropped a claim against the village for money damages. Now, why would they do that? First, they sue for money, and then they file an amended complaint where they say, we don't want money, we want a court declaration that we're allowed to put up an Eruv. Because when you sue for money, that triggers responsibility by an insurance company to appoint an attorney to defend the case. and to indemnify in case there are damages. So by dropping the claim for damages, I guess it was their hope that the village's insurer would say, okay, we're off the hook. Village of West Hampton Beach, you're on your own with regard to your attorney. The village was able to work out an agreement with the village's insurance company that the insurer would continue to pay for the lawyer to defend the case up to a point, but it would not pay for any appeals. And so while the other two municipalities had taxpayer money paying to fight this Eruv case, the village of West Hampton Beach was relatively lucky in that the taxpayers didn't pay for it, the village's insurer did under that agreement. Now, when the amended complaint was filed, we answered, because the judge wasn't going to dismiss the case, now we had to answer, and we also filed a counterclaim, which was our argument that the Eruv would not be legal. And we had two claims on that. First, we said the poles on which the Leckies would be placed are on public property, and those poles were licensed in the early part of the 20th century to the predecessors of LIPA and Verizon. And they were given the authority to put up those poles on public property for utility purposes only. These utilities don't have the authority, we argued, to then turn around and sub-license their poles to a private group for a religious reason or any other reason. The second point that we made, the second part of the counterclaim, was the Constitution doesn't allow religious symbols on government property. That's the Establishment Clause of the First Amendment. And so we had that issue in the case. Now, when the judge denied the motion to dismiss and denied the preliminary injunction, the plaintiff's lawyers called me and said, we just want to give you notice we're putting up the Eruv. The judge didn't stop us, and you told the court that the sign ordinance doesn't prevent it, so we're putting them up. In consultation with the village board, we thought that it would be better to litigate this issue before the Eruv, all these issues, to litigate this before the Eruv gets up. And so we agreed with the plaintiffs that, A, you won't put up the Eruv until the court decides the issues that we've raised in our counterclaim. But at the same time, in order for the court to decide those issues that we've now raised, we will not move to dismiss the case. So we gave that up. We're not going to move to dismiss the case because the village hasn't done anything. That was our argument all along. But at the same time, you agree you're not going to put up the Eruv until the court decides these issues. And that is where matters stood, and the parties engaged in extensive document discovery, exchanging documents and things of that nature. And what happened next is, in the spring of 2013, the parties briefed the issue in briefs this high about whether LIPA and Verizon are allowed.
Can we have a picture? It's six inches high,
Yes.
billions of words.
Briefed the issue extensively before the judge on whether the franchises that were ultimately issued in the early part of the century to the utilities allow these utilities to sublicense their poles, or are they restricted to what we said the language was, to provide utility service. The judge took a while to decide that issue and issued a lengthy opinion finding that the franchises do not prevent LIPA, Verizon, from sublicensing their poles to the utilities. So that's one issue on our character claim that we lost. You can check that one off. But you may say, what about the Establishment Clause claim that the First Amendment doesn't allow religious symbols on public property? We didn't even have a chance to get to that issue because essentially we were deprived of that opportunity by other litigation. Let me explain. When these cases were filed, a group called the Jewish People for the Betterment of West Hampton Beach, JPO, wanted to intervene in our case. They say, we have a view on this issue. We want a seat at the table to have our voice in this litigation heard. Judge Wexler, federal judge in Central Islip, denied their motion and said, this litigation is not involving you. You cannot intervene. They appealed, went to the Second Circuit. Second Circuit affirmed they have no right to intervene in this litigation. Okay, JPO says, well, if we can't intervene in that litigation, we're going to file our own. So we're going to sue the East End Eruv Association and the utilities, and we're going to argue that it violates the Establishment Clause of the Constitution to put these religious symbols on public property. Exactly the argument that we were prepared to make. The judge dismissed their case entirely, Judge Wexler, without an opinion. Dismissed, just like that. JPO then went up to the Second Circuit. That's one step below the U.S. Supreme Court. District Court, Second Circuit, U.S. Supreme Court. The appeal was really the first time that this issue had been aired and briefed and argued anywhere in any court related to this particular Eruv. I attended the argument in Manhattan. The oral argument was a massacre. 5 seconds into the oral argument, it was clear that the three-judge panel didn't like the argument that JPO was making. And it's not that JPO didn't cite the right cases, didn't argue intelligently and forcefully. They did. and the court was extremely, extremely hostile. But, you know, sometimes you get before a court and they seem hostile, and then you get the decision and, wow, I didn't think they were going to come out with that opinion from the way the questions they were asking. So sure enough, a couple of weeks later, we get the opinion from the Second Circuit. Let me tell you what it says. It says an Eruv, quote, is a, quote, demarcation of a defined geographic area within which adherents subscribing to a certain interpretation of Jewish law believe that they may perform certain activities that are otherwise prohibited on the Jewish Sabbath and Yom Kippur, close quote. It is undisputed, that means JPO agrees, the Eruv Association agrees, and the utilities agree. It is undisputed that the West Hampton Eruv was delineated by, quote, nearly invisible, close quote, staves and wires attached to utility poles. The plaintiffs, that's JPO, do not allege that these staves contain any overtly religious features that would distinguish them to a casual observer as any different from strips of material that might be attached to utility poles for secular purposes. Plaintiffs, that's JPO, have not plausibly pleaded that there was no secular purpose to the governmental action here. LIPA entered into a paid licensing agreement allowing the installation of items of religious significance on utility poles. While plaintiffs repeatedly state in their complaint that the establishment of an Eruv serves no secular purpose, the complaint does not contain similar allegations with regard to LIPA's action of permitting the EEEA to attach lekis to its utility poles, and does not allege that LIPA granted access to its utility poles in a non-neutral manner. In other words, JPO didn't allege, and really couldn't, that LIPA is allowing these things on their poles, these religious items on their poles, but they don't allow secular items on their poles. They couldn't allege that because it wouldn't be true. The Second Circuit says, quote, neutral accommodation of religious practice qualifies as a secular purpose under Lemon. I'm not going to go into a whole explanation of the Lemon case and the court's tests on the Establishment Clause. So I'll skip over that a little bit. But the court says, no reasonable observer who notices the strips on LIPA utility poles would draw the conclusion that a state actor is thereby endorsing religion, even assuming that a reasonable observer is aware that a state actor, that's LIPA, government agency, was the entity that contracted with the private party to lease the space. They go on. Compared with many government actions that have survived the Lemon test, LIPA's accommodation of the Eruv has more of a secular purpose, causes less, and that's in italics, less of an advancement of religion, and fosters less church and state entanglement. And they cite a case, Good News Club, Supreme Court, allowing a, quote, private Christian organization for children, close quote, to hold meetings at a public school for the purpose of conducting religious instruction and Bible study. Lynch v. Donnelly, allowing a Christmas nativity scene display on public property. Newton v. Peterson, Second Circuit, 2014, upholding federal statutes requiring the motto, "In God We Trust," to appear on all U.S. currency. A fortiori, LIPA's action in permitting the EEEA to erect the Eruv is not an unconstitutional establishment of religion. And then they say, every court to have considered whether similar government actions violate the Establishment Clause has agreed they do not. That's the Second Circuit. We're in Islip. We're in the Second Circuit. This decision is binding on our court. It's binding on our case. There's no way around it. Well, there is one way around it, and that's to lose, make the argument again in our case, lose, go up to the Second Circuit, the court that issued this, lose again, and then try to go to the U.S. Supreme Court. The U.S. Supreme Court doesn't take every case on appeal. People think, oh, we're going to go right to the Supreme Court. It does not work that way. The court has to first agree to take the case. They get 20,000 applications a year for them to hear my case. My case is the most important. 20,000 cases a year. They decide about 100 to 150. Your chances of getting past this and getting to the Supreme Court, and then assuming that the Supreme Court would somehow think differently than this, are pretty slim. So, what happens is the court comes out with the decision saying the utilities have the right to put it up. Another court, a higher court than our court, says it's not unconstitutional. And the Eruv Association calls me and says, we are putting up the Eruv. And according to them, it's up. What's left in our case, you would say? What's left in our case is what they originally brought the case with, an argument that the village somehow impeded them in their desire to put up the Eruv by scaring off LIPA and Verizon initially with that letter, with statements, public statements by government officials, trustees, the mayor, I'm against the Eruv, we won't allow the Eruv in this village, I don't think the Eruv is proper, we're going to do everything we can to prevent the Eruv. All of that kind of stuff they're going to argue means the village was against it, they didn't even have to bother to apply. Do we want to litigate that question, or recognizing that the Eruv is up, do we want to put an end to this litigation? And that's where we are. I'm not going to tell you what we're going to do, why we're going to do it, what our options are, what our likelihood is of appeals on certain issues. I'm not here for that. But let's take a look at Southampton. Southampton, remember, they were sliced off from our case, and the plaintiffs went their merry way. Judge Wexler told them, you want to put up an Eruv, go apply in Southampton. Southampton said, our sign ordinance says you can't put that up in Southampton. And they applied, and the Southampton building inspector denied the application, and they went to the Zoning Board of Appeals to appeal that interpretation, and the Southampton Zoning Board of Appeals said, we agree with the building inspector, the sign ordinance here doesn't prevent it. And maybe people were thinking, gee, It's too bad we're not Southampton. They have a sign ordinance. Our people here in West Hampton Beach, I wish we had a sign ordinance, because look at Southampton. They're in a better position. Well, when the Southampton Zoning Board of Appeals said, we agree with the building inspector, the sign ordinance prevents it, the EEA went to state court in Riverhead, and about 2 weeks ago, the judge in Riverhead said, I don't see it that way. The sign ordinance does not prevent the Eruv in Southampton. Southampton decided, after paying their lawyers somewhere upwards of $800,000 of taxpayer money to fight this issue, they decided to pull the plug on the litigation and enter into settlement discussions with the Eruv Association. They don't have a settlement yet, as far as I understand. And really, that's where we are. If anybody has a case that's more authoritative and more governing of the issues in this case, submit them to me privately. I'll give you my email address. You could email me any case that you think is going to trump the Second Circuit and Magistrate Judge Tomlinson's decision. And
Brian, could you tell us what's the status with Quag?
Quag, there was an application made to Quag. Quag denied the application under their sign ordinance, and the question there is whether it's the federal judge who's going to hear the challenge to Quag's sign ordinance interpretation, or should that go to state court like Southampton did. Once we'll find out, I guess, unless Quag, whatever Quag does, but assuming that there's no settlement to the Quag matter, we'll find out which court is going to decide Quag's sign ordinance, and then we'll see. But even an interpretation of Quag's sign ordinance, there's still the Second Circuit opinion in the JPO case that has to be reckoned with somewhere along the way. I'll take questions, but I'm not going to engage in a legal debate. I'm not going to tell you what I can't tell you.
Just a question.
Yeah, sure.
Just a question.
Yeah.
Since you're up there and I'm down here, I'll just announce that I'm Dean Spear of West Hampton Beach, Main Street, West Hampton Beach. When the E3A filed their application
What application?
for an Eruv,
Where?
that's my question. They seemed not to have any, now I understand from talking with several people that there have been several maps, different maps introduced during court proceedings, okay? But originally, when you followed the description in their original application of 4 or 5 years ago, that none of it was in West Hampton Beach. That the reason they had included that Southampton Town was involved in this is because they surrounded West Hampton Beach with unincorporated areas of Southampton Town, such as Quayog and West Hampton. How did West Hampton Beach get into this?
I don't know. I can't vouch for the history of what their proposals were. I can tell you that they've made several changes along the way. When we first had our first conference in the case, Robert Sugarman, the plaintiff's lawyer, came into court with a big piece of wood that looked like a 2x4. And he says, Judge Wexler, I want to show you This is what a lecky looks like. It's a piece of wood. You can't tell, you don't know what it is. Okay? Next time we come to court, maybe not the next time, but on some future time when they amended the complaint, he comes into court with a piece of plastic. This is what it looks like. Am I to tell them it's not a valid Eruv with a piece of plastic, you need wood? That's for rabbis, that's not for us. They initially had the Eruv including poles on Dune Road. And we argued in that extensive briefing on the issue of the Utilities Authority that the poles on Dune Road really have a different provenance than the other poles, because the poles on Dune Road were actually constructed by the Coast Guard after the hurricane of 1938 to facilitate communication. And then it was transferred. And so whatever interpretation you want to give to the franchises for the other poles, this one stands differently. And in the preliminary injunction hearing, I recall one of their witnesses saying, we need the poles on Dune Road to basically close the circuit. They explained that Eruv has to be a closed circuit. The northern boundary, the Long Island Railroad tracks are deemed the northern boundary, whatever it is, that closes the circuit. Well, lo and behold, when we submitted our brief and we had a point about the poles on Dune Road, they put in a response and an affidavit that said, due to, I don't want to misquote them, but due to either man-made or natural changes, I don't recall exactly, due to changes, our rabbis tell us we no longer need the poles on Dune Road. Now, I'm going to say to them, oh yes you do, in Eruv you need those poles on Dune Road. That's not our place. If you want to know why they changed their Eruv, why it's on this street, then they moved it to this street, you really have to ask them that. I have no idea.
I was just basing it on the map that was on the Hampton Synagogue's website, the original map, and locating what the line was. And initially, I believe the line was south of any utility poles. They were using the ocean as a natural demarcation and such. So I just trying to figure out how West Hampton Beach was surrounded but not approached directly, how West Hampton Beach got hooked into this.
I can't answer that. Let me say something else. I'm aware that a law school professor, I think in Maryland, wrote a law review article several years ago where she opined that, in her view, an Eruv is unconstitutional under the Establishment Clause. It's a religious symbol on public property. And when this case came in, I found that law review article before anybody. I cited it in our motions. But a law review article is great. It's nice that a professor was thinking of these things, but a law review article is not the law. What the Second Circuit says is the law. So, there we are. Nobody laid down and died in this litigation. The lawyers, the trustees, everybody has, up to this point, and if we don't have a settlement, everybody will give it everything that we have available.
Yeah, Michael Novoletti, West Hampton Beach. Are you saying that the JPO decision has now avoided your ability to represent the West Hampton Beach village case?
No, it hasn't affected my ability to represent the village, but it's laid out the law. It laid out the law that governs our case. It's the same Eruv.
Right, but the arguments of West Hampton Beach are distinct from the JPO arguments. Is that correct?
I'm not gonna get into that.
You already did.
Well, okay. All right, but going back, when you creating the quad and getting back into the municipal progression of the sign code, you went to the West Hampton Beach building inspector. He has made a determination. Why didn't you go to the West Hampton Beach zoning board of appeals as the court of original jurisdiction for that code for an opinion as to what the West Hampton Beach law said? And if it says that sign law is in violation and cannot have that, then we would argue in a similar matter that the zoning code, according to the zoning board, prevents these items from being put.
My purpose here is not to tell you why we did something or didn't do something. The West Hampton building inspector gave what I understood to be the authoritative interpretation of the building, of the sign code, and there we are.
Steve, is not the zoning board original jurisdiction for that code?
No, it wouldn't be presented that way, because from what Brian was saying, the issue came up on a declaratory judgment. No, the only way that the zoning board would be involved, if somebody made a direct application for relief from the zoning board for some sort of variance, or there would be an appeal from the determination of the building inspector. That had never been done. So the zoning board doesn't exercise jurisdiction on its own. It would not have jurisdiction in this case, and that issue, and I don't know the timing, but the issue would have been trumped by the declaratory judgment, right, Brian?
Yeah.
I would think.
My name's Pamela Schaefer. I'm here. My husband, Arnold Schaefer, is chairman of the JPOE, and he could not be here tonight, so unfortunately you get me to represent him. But first of all, I want to thank you for a very cogent explanation of the court cases, which are very difficult. I myself have read through a lot of things, and as a layman, it's very hard, and I think you did a very good job of explaining to laymen. And we will be watching your, on the video, my husband will see that.
This is on video? I would have won makeup.
The request that we, personally, my husband and I and some of the members and JPO had of the board was exactly what you have answered. We did not expect any strategy. We did not expect any future. We were actually asking to have laid out in your interpretation what exactly has gone on up to date, and I can thank you very much for that. And later I'd like to say something to the board, but I just want to thank you.
Listen,
for
if
all
the
that.
day,
Very good.
if the day comes, and the day will come, when this litigation is over, one way or the other, I'll be happy to give you my personal opinion on what I think the courts should have done, and I'm sure the trustees will also will do so also. But it's just irresponsible to press them for their personal opinions, and I know I've read this over and over. It's just irresponsible to put them in that position to have to answer questions that really could be used against them. Whatever answer they give could be used against them in the litigation. And whoever continues to press them for answers that way really doesn't understand that concept, that anything they say is potential evidence. And frankly, you ought to know anything that anybody in the public, in a public meeting, anything that any member says could potentially be used in this village. And I've had this experience. I was involved in litigation with respect to the formation of a village in Rockland County, and the claim was that the village was formed to keep Orthodox Jews out by not allowing home synagogues. And the argument was that the Civic Association formed this village to keep Orthodox Jews out. And by enacting a zoning code that didn't allow residences to be used as home synagogues. And they claimed that was the purpose behind the formation of the village. And we had a 6-week trial on this issue. And at that trial, a number of the plaintiffs got up on the witness stand and started to testify about the fact that I was walking on Route 59 in Rockland County, and some car sped by, and somebody rolled down the window and said, "Hitler didn't finish the job," or "Go back to Brooklyn," or any other kind of epithets. Anonymous people riding by in a car. And I stood up and I said, "Your Honor, I object. There's no connect. They don't even know who this was. There's no connection to my clients who formed the village. This is irrelevant." And the judge said, "I'll allow it for atmosphere." In other words, I will allow it to show the conditions in which these people, and I remember I say, "Judge, the atmosphere, this is not a case about the weather. It's a case about what my clients did." But nonetheless, federal judge, he was a very good judge, allowed that kind of evidence. So I want everybody in the public to understand that you could stand up and make statements at public meetings, and your village officials could have the purest heart and the best motives. And the fact that somebody got up and said ugly things at a public meeting might come into evidence and taint a pure decision by village officials. So, members of the public, you have to be very careful with the rhetoric. Of course, you have a First Amendment right. This is not censorship. You have a First Amendment right, but I'm just saying you have to be conscious of the effect that some things that you say might have on the issues that you are interested in, may have unintended consequences.
Brian, are you able to speak about the issue of the claim for attorney's fees from the
Yes.
plaintiffs?
Thank you, Mayor. You might say to yourself, they're not suing for money. What do we have to lose? Let's roll the dice and see what the court says. That would be nice if in the 1970s, Congress didn't pass a law that said that prevailing plaintiffs, actually it says prevailing parties, but it's largely used, prevailing plaintiffs are entitled to their attorney's fees. So if the plaintiffs get a determination that the village impeded their efforts, then we will get an application by the plaintiffs to have their attorney's fees paid. I'll argue that they're not entitled to attorney's fees in this situation, but that will be an argument that will have to be decided. And then there might be an issue, I don't know, it's not my bailiwick, between the insurance company and the village about who's responsible for the attorney's fees. So it's not as though go ahead and see what happens. We have nothing to lose. I'll say no more.
Have they indicated the amount of the attorney's fees?
Over $1 million.
Over $1 million. And if Southampton settles the case, then they would not be on the hook for that kind of an award?
It depends on the settlement, but I wouldn't expect their settlement to include attorney's fees.
Are these attorney fees on top of Mr. Sugarman's work? Because he has always stated that he worked pro bono.
He works pro bono until
For them.
he prevails on a civil rights claim, and then he's entitled to be paid. That's the way that works.
Not by them, but by
No,
By us.
Unfortunately, I understand.
The idea is, behind this statute, that Congress wants to encourage lawyers to bring civil rights cases because it protects, the Attorney General of the United States can't bring suits for everybody, so we want to encourage lawyers to act as private attorneys general. So we're going to change the American rule. If you bring a civil rights case, and you win, you get full attorney's fees.
Is this $1 million the entire, or this is just for West Hampton?
Well, it would only be, if they won against West Hampton, it would only be against West Hampton.
So they could only charge the fees for their work for
Right,
West Hampton?
and then you have then it's like the bucket brigade that comes by after the parade. Then you argue, well, that 30-minute phone call, you spent 20 minutes talking about Quogue and 10 minutes about West Hampton Beach. It's kind of ugly litigation.
I have a question. Regarding the First Amendment, Carol Matthews, West Hampton Beach. Regarding the First Amendment of covering the religious, in other words, the Second District Court said it doesn't apply?
The Second Circuit said that the leckies on utility poles do not violate the Establishment Clause of the First Amendment.
Why would they decide that? Because it was a small plastic thing? What if it was a big thing? I don't understand how they can decide that it's not against what the...
They're only going to decide what's before them. They didn't have a big thing. They had before them, the leckies that the plaintiff said they were going to put up.
What's going to stop any other religion from doing something like this? It's not just the Jewish religion. It could trigger something. It could drive a lot of people in other religions to put stuff on the pole and get away with it.
If there's a different religious object that a court feels is more apparent and more of an endorsement of a religion than a lecky, then maybe a court will decide that case differently. But that's not the issue before the court now.
But the court already decided that the lecce is okay. They
They
decided what is permitted on that pole regarding to what they're using.
decided that their object in this circumstance doesn't violate the First Amendment. They didn't decide anything more than that.
You can't pursue it through that way?
No, you just can't
That
go.
they can make the decision of what they want on a pole that belongs to someone else?
This is,
In
we've been.
our own codes?
Every issue that you're raising, we've raised. And we've gotten decisions. And if you're aware of any other court that decided these issues with similar things different ways, call me up. I'm all ears.
I wish I knew.
I do too.
I wish I knew. But I feel that the Second District Court is making a decision among themselves. And how
Well,
can
all
they
I can
do
tell
that?
you is if you're not happy with the federal judges that decided this case,
Election
you
day.
write to your congressman or your senator and tell them stop appointing judges like that. That's all I can tell you.
It's an endless battle, to tell you the truth, unless you keep going, and it's up to our board to make that decision. And I feel for them, because that's a big decision to make, if you want to pursue it. That's a really big decision.
My question is, was the J-PO case, did that argue all of the elements of the West Hampton case?
Absolutely.
There was nothing that you would have added in the J-PO case, or there was not any omissions or that could have had the West
The
Hampton case
lawyer
prevail?
did a fantastic job. He did. I was impressed. And he stood up there before that court. It was like a fusillade. And he was very, very good.
Correct me if I'm wrong, but I believe Mr. Sugarman stated in one of his briefs that if the court denied the Eruv, it could or would be a precedent for every Eruv in the United States to come down.
He did say that.
Which shows the difficulty of a court ruling in our favor.
Right.
And I'm not sure that that's been publicized enough.
Well, thank you, Mr.
Thank you.
Sokoloff. Well, nicely done. We
Thank you.
appreciate it very much.
Thank you very much.
All right.
Very informative.